Classifying a worker as an employee or independent contractor is perhaps the most important legal factor for companies that do business in California. Classification of workers determines everything from compensation, benefits, and job protection to tax obligations and labor law compliance. To provide equal treatment to workers and avoid misclassification, California law mandates the application of the ABC test, a legal rule with set standards for determining employment status. Following the Dynamex Operations West Inc. versus Superior Court ruling, the test was codified into law and subsequently reaffirmed by Assembly Bill 5, AB 5, and its subsequent amendments. For employers, misclassification of employees as independent contractors may result in costly penalties, legal liability, and monetary losses. For employees, misclassification may translate into foregone wages, diminished benefits, and restricted legal recourse. It is important for both employers and employees to understand how the ABC test works in order to remain compliant with California labor laws. What is the ABC test? The ABC test is the legal framework in California that is used to decide if an individual should be classified as an employee or independent contractor. The test was designed to avoid companies from misclassifying workers and depriving them of necessary benefits like minimum wage, overtime pay, and unemployment insurance. The ABC test was initially established in the groundbreaking Dynamex Operations West Incorporated v. Superior Court case in 2018, and then enshrined into legislation through Assembly Bill 5, AB 5, in 2020. It puts the responsibility on the employers to demonstrate that a worker is an independent contractor by meeting 3 stringent requirements. A. The employee must not be subject to the hiring company's control or direction. B. The work done should be outside the ordinary course of the hiring entity's business. C. The employee must be engaged in an independently established occupation, trade, or business. If an employee fails any of these 3 requirements, they would have to be defined as an employee under California law. The ABC test is the default standard for classifying workers in most sectors, with some exempt occupations subject to alternate legal standards, such as the Borrello test. This classification system ensures fair treatment of workers and adherence to California labor laws on the part of businesses to minimize the chances of exploitation and misclassification. The ABC test: How California determines worker status. The ABC test is the legal standard California applies to determine whether a worker is an independent contractor or an employee. According to this test, a worker is deemed an employee unless all 3 of the following are satisfied. A. The worker is free from the control and direction of the hiring entity. This implies that the worker has to work without direct control or supervision on how their job is done. The employing company should not regulate work hours, tools, or methods of getting the job done. A graphic designer brought in for a one-off project and granted artistic license over the way they do the design would probably fulfill this requirement. But if the company imposes certain working hours, supplies the equipment, and scrutinizes their work, they are probably an employee. B. The work performed is outside the usual course of the hiring entity's business. The job of the worker should be distinct from the main operations of the business. If the services offered are central to the company's main operation, the worker is an employee. Example: a bakery employing a plumber to repair the kitchen sink would pass this test because plumbing is not included in the normal business activities of a bakery. But employing a baker as an independent contractor to produce bread daily would fail this requirement because baking is the business's core function. California labor laws are designed to protect both employers and employees. It is crucial for all parties to understand their rights and responsibilities under these laws. Employers must comply with regulations regarding wages, working conditions, and employee rights. Employees, on the other hand, need to be aware of their entitlements, such as minimum wage, overtime pay, and workplace safety. Both employers and employees should stay informed to ensure a fair and lawful work environment. Always consult legal professionals for specific guidance related to your situation. The worker is engaged in an independently established trade, occupation, or business. The employee should be actively operating their own business or providing the same services to other customers. This implies they must have business registrations, advertisements, or several clients, evidencing they are actually independent. Example: a freelance writer with several clients that she or he promotes their services online would fulfill this requirement. Conversely, a full-time content writer employed by one company who does not operate an independent business would probably qualify as an employee. If a worker does not meet any of these three requirements, they must be considered an employee under California law. Why worker classification matters. Misclassifying workers has serious consequences affecting both businesses and employees.